Good afternoon, everyone, and welcome to the OSHA 3030 with Manesh Rath. We've got a great topic today. The DC Circuit just ruled on a suit against OSHA with respect to the coronavirus pandemic and OSHA's decision to not issue a emergency temporary standard. So we'll talk about that, as well as some of the critical features of OSHA law that are implicated with this suit and some related issues. Let me take a moment to allow people to dial in to catch up, but while that's taking place, let me just point out that this is a webinar that we've been doing for over 7 years. Every single month, we do a new topic every month in about every 30 days, and we try and cover a developmental issue in about 30 minutes, plus the title. And the members of the OSHA 3030 community have been participating consistently, coming back for many, many years and sharing the good word with other people involved in the Office of General Counsel or safety and health professionals at corporations around the country, in fact, around the world. And that's been great to see. This program is something we do for friends and clients of the law firm Keller and Heckman. And it's also important to note that we do this complimentary to you as a service to our clients and friends of the firm. So the only thing we ask is when you get this announcement as an email, please forward it on to 3 others involved in safety and health, either in-house or safety and health professionals. Even if you've already done so before, please forward it on to 3 more and help keep spreading the word so that the program can keep going. With that said, let me introduce the faculty for today's episode of the OSHA 3030. As you know, I am Manesh Rath. I'm an attorney here at the law firm Keller and Heckman in our Washington, D.C. office, and I am a part of our OSHA practice. I'm joined today by another member of our OSHA practice, attorney JAVANEH NEKOOMARAM, who focuses on occupational safety and health law as well as various aspects of environmental law. JAVANEH, thank you, and thank you for joining us, and welcome to the OSHA 3030 today.
Hi, Manesh. Thank you so much for having me.
Well, JAVANEH, as you know, we've got a great topic. We've had a lot of great topics over the years, and they're all libraried on our website, khlaw.com/OSHA3030, many of which are still very informative and relevant to this day. So for those of you who haven't caught all the episodes, it's worth a few minutes to browse through our library at khlaw.com/OSHA3030 and see if there are other topics that interest you. The slides and the sound combined in one self-executing file. Also, don't forget to subscribe as a podcast through your favorite podcast media like Apple Podcast app, or we're even now on Spotify as well as on SoundCloud. So what we're going to talk about today is the AFL-CIO's emergency petition to OSHA and its ensuing lawsuit against OSHA to implement an emergency temporary standard, the court's analysis of that complaint, and in light of the court's decision, what OSHA's approach is to managing the coronavirus pandemic with respect to workplace safety and health. Finally, as we always do, we'll finish off with a discussion of practical takeaway items for you, listening members of our community, in a slide we call What Employers Should Do. So with that said, let's talk about this case. So the AFL-CIO, they issued a request in the form of a petition to the U.S. Occupational Safety and Health Administration. And essentially, they asked OSHA, the Occupational Safety and Health Act permits the agency to issue an emergency temporary standard without the need for full-blown notice and comment rulemaking, and because it's on an emergency basis, and you should do so in order to develop an emergency temporary standard that specifically addresses the control measures that employers need to be taking in the workplace with respect to the coronavirus pandemic. And there's no specific standard on points, the AFL-CIO argued, and guidance doesn't have the same mandatory or enforceable quality that an emergency temporary standard would. And so we want you to do this. We want you to issue an emergency temporary standard. OSHA OSHA's non-response was taken by the AFL-CIO as a denial of its petition, and OSHA filed suit with the U.S. Court of Appeals for the circuit for the District of Columbia, which we'll refer to as the D.C. Circuit. This is the U.S. Court of Appeals for the D.C. Circuit. And it's essentially a petition for a writ of mandamus, arguing that OSHA should be compelled by the courts to issue an emergency temporary standard, and it pled for the courts to issue an order that OSHA must do so within 30 days. OSHA responded to the court with they responded to the AFL-CIO with a denial of the AFL-CIO's petition for emergency temporary standard, and then responded to court. JAVANEH, I think that the arguments that both parties made are extremely informative for us in the OSHA 3030 community.
Yes. So getting into the case, I think it's important to understand what is required of OSHA to find before it decides an emergency temporary standard is appropriate. So Section 6 of the OSHA Act gives OSHA the authority to issue an emergency temporary standard if OSHA determines that employees are exposed to grave danger from exposure to a new hazard and that an emergency standard is necessary to protect employees from such danger. So if OSHA issues an emergency temporary standard, it would take effect immediately until it's eventually superseded by a permanent standard that OSHA is supposed to issue within 6 months of the emergency temporary standard. So AFL-CIO, here they argue that an emergency temporary standard is appropriate because COVID-19 puts employees in grave danger, saying that the virus poses a danger of incurable or permanent or fatal consequences to workers. And they cite to the figures that over 2 million people in the U.S. have been infected by the virus and about 110,000 people have died. They also discuss how the dangers of COVID-19 are especially true of workers who are deemed to be essential workers. So they were continuing to go into work. And, of course, healthcare workers and nursing home aides and first responders, people who come in direct contact with those who have the virus, and also for workers who are now starting to go back to work as state stay-at-home orders are lifted. So the AFL-CIO argued that an OSHA standard for infectious diseases is necessary to protect employees from this grave danger. And they asked OSHA to issue this standard, which would require employers to evaluate their workplaces for the risk of airborne disease transmission.
Yeah, and JAVANEH, I want to point out one more thing. When you talk about essential workers and in addition, healthcare providers, nursing aides, first responders, essential workers is a very large segment of our listening community. It includes anyone in almost all manufacturing sectors, food manufacturing, retail of essential goods. It involves construction, commercial and residential construction in almost all states. At some point, some states had ruled some of them, some subsectors to be non-essential, but almost all sectors of construction are considered essential. Transportation is considered essential. Communications is considered essential. So those are all contemplated within the scope of the AFL-CIO's claim that essential workers should be protected under an emergency temporary standard. I just wanted to clarify that.
Yep. Right. Yes. And so the AFL-CIO, they called OSHA's refusal to take action on an emergency temporary standard a stunning act of nonfeasance in the midst of this of COVID-19, as they call it, a workplace health emergency. And so they're arguing that an emergency temporary standard is required and that the court should order OSHA to issue one.
It's an interesting point that they're saying that OSHA's provision for emergency temporary standards, if it's not implemented when the AFL-CIO thinks it should be, that would be an act of nonfeasance. I think that was more probably rhetorical than an argument founded in law. But I think that the legal basis for the D.C. Circuit to rule on this question is equally interesting.
Absolutely. So getting into the D.C. Circuit's ruling, we wanted to give some background on the level of deference that the D.C. Circuit should afford OSHA when it decides whether or not to issue an emergency temporary standard. So the D.C. Circuit here, they look to precedent in the Public Citizen Health Research Group versus Oucher case, which is a 1983 case in the D.C. Circuit, where the court decided that OSHA is entitled to considerable deference in deciding whether or not to issue an emergency temporary standard unless their decision lacks support in the record. So that was the standard applied in this case by the D.C. Circuit.
So I guess it's important to point out some of the so that was the precedent in the case, and I think it's important to understand the kinds of methods by which OSHA can make pronouncements about workplace safety and health. The Act, which was promulgated in 1970, first of all, created OSHA, the agency, and then it directed OSHA, the agency, to promulgate specific regulations on specific elements of safety and health. In addition, the Act has this general duty clause concept, and the general duty clause essentially is a catch-all mandate that every employer shall provide a workplace that's free of recognized safety and health hazards, and to the extent practicable. And then, in addition, there are countless interpretation documents, letters of interpretation, for example, but as well these guidance documents that OSHA can publish without having to go through rulemaking. And they are interpretive. Some of the specific regulations that, to a limited extent, apply to coronavirus include standards for personal protective equipment, such as eye protection. There's a standard for housekeeping and sanitation. There's a record-keeping standard where work-related cases of coronavirus positive should be recorded. Many people think the bloodborne pathogen standard would be applicable, but in fact, coronavirus is not a bloodborne pathogen. It's respirably transmitted and does therefore not get covered by the bloodborne pathogen standard. OSHA has therefore opined that the basic principles of infection control found in the bloodborne pathogen standard should be studied and employers should consider which of those elements are applicable, but it is not itself an applicable standard for the purpose of coronavirus. So this is important because this is the basis for which OSHA has decided to issue guidance documents related to coronavirus and why the AFL-CIO would want a specific emergency temporary standard on point. So JAVANEH, let's talk about the arguments that each of the parties made before the D.C. Circuit.
So OSHA, they explained that they have a two-pronged strategy for addressing COVID-19, and that is enforcing existing standards as well as using what they call rapid and flexible guidance that is industry-specific so that it can be easily updated as information on COVID-19 and the spread of the virus continues to evolve. And so using its existing tools like existing standards, the general duty clause, and guidance, OSHA argued that this was a flexible and effective method at addressing the COVID-19 pandemic, and therefore the emergency temporary standard is not necessary. And further, they argue that the AFL-CIO the AFL-CIO lacks evidence that the current methods that OSHA is using are ineffective at addressing the hazard of coronavirus. And then,
well, I think that's all really important to consider. And there's also another thing that really didn't get spoken about in this case, I suspect, and that's that when the coronavirus phenomenon first appeared, there was very little that was understood. And even now, it is a developing area of medical science, and infection control is a part of that developing body of knowledge. And so OSHA essentially argued that it could be able to adapt more nimbly to this changing landscape with the possibility of issuing guidance documents rather than the emergency temporary standards.
That's right. And the AFL-CIO, their concerns with OSHA's approach are that, guidance is non-mandatory and there could be non-uniform implementation. And also they were concerned that the general duty clause could be too difficult to prove. And so they argued that an emergency temporary standard is the appropriate approach. However, as you know,
JAVANEH, as you note here, their argument that they could much more nimbly and quickly address workplace safety issues related to coronavirus through guidances has proven to a certain extent to be supported by the guidances they have issued. Wouldn't you think?
Right, agreed. OSHA has issued a lot of very tailored guidance in response to COVID-19. So they first issued, general guidance for preparing the workplace for COVID, but then they also issued respirator-specific guidance. There are about 5 different types of guidance out there addressing, respirator shortages and proper use of respirators. Also, guidance on reporting and record keeping of COVID-19 cases. And then OSHA has issued 9 different guidances for very particular high-risk industries, like, folks who deliver food delivery services and emergency responders and workers who work in nursing homes. And so OSHA tried to really tailor the needs of each industry and provide specific guidance that way.
Other industries that have a specific industry guidance include meatpacking, pharmacy, retail pharmacy, the limousine and taxi passenger transportation industry. And I don't think that these are necessarily the highest risk environments, although dentistry is in there and it's widely considered one of the highest risk workplace environments. But they are the ones they're the first 9 certainly to have seen an OSHA guidance that's specific to their industry. Agriculture is the most recent. Guidance came out on June 2 last week relating to agriculture. So,
right, and so, yeah.
JAVANEH, go ahead.
Yes, and so not only has OSHA pointed to its existing standards that that may not be directly addressing COVID-19, but they are relevant to addressing the hazards that COVID-19 presents, as well as guidance. OSHA also pointed to the general duty clause. They asserted that the general duty clause imposes an additional mandatory obligation on employers. As Manesh mentioned earlier, under the OSHA Act, employers are required to furnish employees a workplace free from recognized hazards that cause or are likely to cause death or serious physical harm. And so OSHA can cite an employer under the general duty clause if the employer fails to keep the workplace free of hazards that employees are exposed to, and that the hazard is recognized, and the hazard caused or was likely to cause death or serious physical harm, and that there was a feasible and useful method to correct the hazard. And so OSHA has acknowledged in its brief that COVID-19 is a recognized hazard, and that employers who fail to take preventative measures against COVID-19 could potentially face liability under the general duty clause. So all of the guidance that the CDC and OSHA and other government authorities have put out, as well as industry guidance, all of those demonstrate possible feasible methods that an employer can use. So employers can choose an effective method to abate the hazard under the general duty clause. And so, in fact, all of this publicly available guidance actually enhances the power of the general duty clause as an enforcement tool.
And this is consistent with one of their specific guidances that employers will be given a little bit of opportunity to show a good faith compliance method. In addition, what we covered last month, I'll repeat, another guidance came out that OSHA will be conducting a lot of its inquiries by sending out inquiry letters rather than making on-site inspections, just to make sure they cover more territory and at the same time don't expose their workers to exposure potentially to coronavirus. So JAVANEH, you covered the general duty clause elements, and I think that that's helpful to make sure we're caught up on. And you can see why, as you describe those elements, the AFL-CIO argued that this is harder for OSHA to enforce because they have to meet all of these elements. And that is one of the inherent problems with the general duty clause, is that the elements necessary to prove a violation of the general duty clause are a little bit more rigorous. But I think that was intentionally designed that way because if OSHA has to assert that this is something widely recognized or that there are feasible means of abatement, then it needs to be able to establish those through a preponderance of evidence. So I think that is a reasonable burden when going to an enforcement action under the general duty clause rather than a specific standard. So JAVANEH, as you know, we've been watching the workplace-related litigation, civil litigation pile up. And the first one that we believe was filed by an employee, the estate of a deceased employee, in fact, was against a Walmart in Cook County, Illinois, alleging failure to adhere to OSHA guidelines and CDC guidances. Since then, we've seen suits filed against a McDonald's, also in Chicago, also in state court, seeking a preliminary injunction against what it claimed were elements of the workplace that the plaintiffs felt was unsafe. Smithfield, which has been in the news for one of the largest work-related outbreaks, and is in an industry with some of the largest work-related outbreaks, is now subject to a public nuisance lawsuit in Missouri, which was dismissed in federal court, JAVANEH?
It was a few weeks ago. So
but the OSHA case is still going forward.
Correct. The OSHA investigation is ongoing. Yes.
And just last week, Amazon was hit with a public nuisance lawsuit for its facility in New York, I believe, right there in New York City. So what we're seeing is employers are subject to the possibility of OSHA inspections, OSHA citations. They're also subject to the possibility of workers' comp claims, but employees are bringing civil lawsuits under tort theories in state and federal courts, arguing that failure to comply with OSHA guidelines, failure to comply with CDC guidelines is tantamount not only to a tort, an actionable lawsuit, but also should be sufficient to overcome a workers' comp bar. Or in the case of public nuisance suits, it doesn't even require a specific physical injury or illness. It may seek injunctive relief to prevent an injury or illness that a plaintiff thinks is imminent. So why don't we conclude with a discussion of what employers should do in light of these developments? Well, we now know that the opportunity for an emergency temporary standard is not imminent. The D.C. Circuit Court has denied the AFL-CIO's petition for writ of mandamus, forcing OSHA to implement an emergency temporary standard. So that won't happen. We can now expect a few things to happen. In addition, at the same time, there was a congressional inquiry under the Workforce Protection Subcommittee, and they inquired why OSHA would not issue an emergency temporary standard. And OSHA's response was essentially the same. In addition to, well, we believe guidance is certainly something we can achieve with much more nimbleness. In addition, they said we can't really get into the particulars of anything relating to the lawsuit itself, because at that time the lawsuit was pending. We can also expect that Congress may craft another coronavirus relief bill, and that proponents of this particular subcommittee hearing may seek to introduce into that bill a rider or an attachment that seeks to mandate that OSHA engage in promulgating an emergency temporary standard. So that's a possibility. Howsoever likely or unlikely that possibility may be, we have to keep our eyes out. for the possibility of a congressionally directed impetus to develop an emergency temporary standard. The other thing I'd say is, as OSHA had argued, that these guidances are much more likely to be the most relevant document from OSHA, and that I think it's reasonable to expect that OSHA will continue to promulgate more and more guidance documents going forward. So they have to be monitored, particularly if one speaks directly to your industry. But if one doesn't speak to your industry and the specific contents within a guidance for some other industry are nevertheless translatable to your industry, you'd have, I think, a tough time as an employer arguing why you didn't comply with those steps, those recommended steps. So it's important to keep up to date of CDC and OSHA guidances, generally speaking, and in addition, those that specifically talk to your specific industry or operations. One of those guidances refers to the idea that an employer should have a written exposure assessment for coronavirus exposure and a written coronavirus control plan. And I think it's safe to say that employers should consider developing their own coronavirus exposure assessment and coronavirus control plan so that they have that document to rely on when defending themselves in these cases as to what their protocols were, their practices, and their engineering controls, and as well their personal protective equipment. And that I think, moreover, it's important to show all of the sources that you use to rely on to develop that plan, including all of the CDC and OSHA guidances. And the last thing I'd say, JAVANEH, and I'd be curious your thoughts on this, is that the training documents, once you develop a control plan, employees need to be trained. Managers need to be trained on the control plan and proper precautions and proper steps that they need to be taking. And those training documents and the training records need to be preserved as well as evidence of fulfillment of that control plan.
Manesh, I agree. I think it's very important to make sure that all efforts to protect employees and train them about the proper use of PPE, proper procedures for whether it's social distancing, hand washing, sanitizing, cleaning, anything that an employer decides to implement, that they record these trainings and put the trainings in writing and also document the source, because as we've seen, guidance changes very frequently as our knowledge of coronavirus evolves and as the circumstances change. So it is important to stay on top of all of those developments and demonstrate that you are monitoring things as they progress.
Right, and when you cite in the development of your written control plan a guidance document, then I think the date of the version of the guidance document that you're citing should be recorded as well, because as you said, JAVANEH, these things do change. The CDC has pulled and revised several guidances relating to coronavirus over the past 2 months, and in some cases they've revised them the same point multiple times. So to preserve the date of the guidance that you relied on in developing a control plan is, to me, a really good practice. Well, JAVANEH, that's it for this month's OSHA 3030. For those of us participating today, you can catch more OSHA developments on Twitter at Rath Manesh. This program is repeated as a podcast as well, so even if you can't tune in to the webinar, you can always catch it on the go as a podcast, and we are on the Apple Podcasts app. We are on SoundCloud, several other podcast apps, and we are now on Spotify. We also, each of us have LinkedIn pages, myself and my colleagues, David Salvati, Larry Halpern, JAVANEH NEKOOMARAM, John Gustafson, and others in our OSHA practice, as well as Keller and Heckman's own Workplace Safety and Health LinkedIn page. Our next OSHA 3030 will be on July 22 at 1 p.m. Eastern Time, always on a Wednesday, always at 1 p.m. And more information can be found on our website, as well as past episodes at khlaw.com/OSHA 3030. For those of you who get that next invitation, please remember to forward it on to 3 more people involved in safety and health in the Office of In-House Counsel or in safety and health at your organization or at other organizations. We have sister programs, PETITION 3030, REACH 3030, and FIFRA 3030, and they're all coming up with new episodes in July as well. On behalf of myself and my colleagues here at Keller and Heckman, I want to thank you, JAVANEH NEKOOMARAM, for joining us today. I want to thank all of you in our community for participating today. And we look forward to seeing you next month. And until then, stay safe.